as part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely green community in the United Kingdom, our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV. Thank you for joining us on the program, and this is Voice coming to you from Ben Television. My name is Tunde Alabi, and this is our educational program where we take a look at legal issues here in the United Kingdom, how decisions, legal matters may affect you, or if you are already affected or if you're concerned about legal issues, how you can get some help, either from a qualified solicitor or from citizens' advice. And the program again is Voice. My name is Tunde Alabi. As usual, my guest on the program today that will join us to look at legal matters is Jennifer Obaseki. Jennifer is a senior partner at Obaseki Solicitors here in the United Kingdom. Jennifer, thank you for being part of the program today.
My pleasure.
Jennifer, we know that the Home Office has begun applying different strategies and, well, let's say tricks now in removal and enforcement of people, undocumented immigrants in the United Kingdom. You want to tell us more about removal notices and enforcement?
Well, we've spoken about how robust the enforcement regime has become. So people who are under the reporting regime that are having to go and sign at reporting centres, at times they're given notices which indicate that they're going to be asked to leave the country or removed, or there is an intention to remove them. So the notices are there and designed so that once they have been given that notice, it triggers either for them to be A, aware, or B, to react. So sometimes you're given a notice, and that may be for you to put forward any additional grounds that you have in support of your case. That's not one that's going to say that you're going to be removed, but it allows you to outline if you've got outstanding submissions, an outstanding application, whether you've got family issues, medical issues. So a statement of additional grounds is where the Home Office says, tell us any additional grounds that we should consider before taking steps to remove you. So if you get a notice of that nature, it's important that you fill it out within the required time, because most of them have time frames. Statements of additional grounds can have up to 10 days notice or sometimes longer. You can ask for that timeline to be extended if you require to get supporting documents. If you cannot get the documents on time, state within the statement of additional grounds what you intend to supply and why you can't get your hands on it. But usually there are phone numbers on the notices. So very important that if it's a statement of additional grounds, that you respond, number one. But number two, that if there's additional information to be submitted, you spell it out on the notice. And again, many people don't really know their immigration history. So it's important that you know where you are. If your previous representative is closed or is not contactable, you should know what was last done for you. So many people have outstanding representations and they don't know. But then again, some people have decisions and they don't know.
Well, what's the difference between notice or notices on additional information and notice or notices on removal?
Okay, the notice of the removal will specifically say, we intend to remove you from the United Kingdom. It will state where to. It will also state the time of which they intend to remove you. So you have an administrative notice that says, okay, we want you to provide us with information, or we intend to remove you and want more information about your family life. Many people that have children are being given notices and questionnaires to fill out so that there can be a full consideration of the family group and the requirements. Some of these notices and questionnaires are very long, and many people may need help filling them out. And because if it's not under asylum, you've made your claim, you may not get funding to help you fill these out. So again, very, very important if you're giving things like that, that you know in your family there's going to be serious issues, i.e. medically, educationally, or maybe children are taking exams. If you have to make submissions as to why you cannot leave at that particular time, whether it's because you can't leave at a particular time or you think that there shouldn't be a decision to remove you, fill out these questionnaires very correctly. But in relation to what you asked as to what is the difference between a notice for information and a notice to remove you, very specifically, the notice that is there to remove you or is to tell you that you're going to be removed, number one, should really give you directions on how you challenge and a deadline for when you challenge. The ones that are being given out now at the reporting centres clearly state that by a certain date you must have lodged a challenge against this decision to remove you. So normally that notice is at approximately 2 days after it's been served. It doesn't give somebody very long, especially if that person is elderly, English is a language problem, or the person's mentally ill. So again, if that timeline is unreasonable because of the person's disabilities or barriers to accessing justice, representations should be made. But not only does it outline where you're going to be removed to, it usually has the flight and vessel number. So if it's a complete removal direction, it will actually have the aircraft number. This is required because...
reporting centre, where
yes,
the person should report to.
If there's an immigration decision, a notice can be served by an immigration officer, and that is somebody that's at the reporting centre. It doesn't necessarily have to come from the Home Office. So many people are going to reporting centres thinking this is just where I report. But anybody that is an immigration in that reporting centre has the authority to serve notices on you. So if they look on the system, they see that you say you haven't received it in the post, they can print it and serve it on you. And you're deemed to have received it there and then. Notices that come by post are deemed served within 2 days of posting. Notices served by email and fax are deemed served instantly. So if somebody, for example, goes to their solicitor and said, I haven't received anything, solicitor phones immigration, and immigration fax or email the notice, is deemed served there and then. Okay? So, because timelines run from the service of a notice. So the time that it's received, how it's received, are very important so that you calculate the correct timeline for you to take the correct action. So if it's 2 days to challenge, if you didn't receive it on time, then you can outline that your 2 days should run from when you received it. But if it was received under the methods that are deemed to be served instantly, then your timeline serves from when it's deemed to be served instantly. But going back to the vessel number, it's very important because if you are seeking a challenge to somebody's removal, number one, you can't go to the High Court and say, look, we want an injunction of stay to stop this person leaving the United Kingdom. It can't be as vague as that. It has to be very specific. It has to be this person, full name, date of birth, cannot leave on this vessel scheduled to leave to Brazil or to wherever and to the known destination. So the vessel flight number, vessel number, all has to be specified in the order you're seeking. Because when we rush to the High Court, we have to rush with such specific facts. As you know, the High Court judges name and shame solicitors who come with frivolous grounds and with badly prepared papers. And even if a client is ill, injured, and you're coming at the last minute, a judge wants to know, why have you waited till now? And look to see if the Home Office have considered it, if they've considered it properly. So that's whether you're ill, you're on medication. So far as the Home Office is aware, you're being removed in a humane manner. a judge may not stop anything. And I would say 8 times out of 10, they are not stopping anything. So it's always very pressurized and stressed at the time. But there are some key things people need to be aware of. Number one, you know, families should not be separated. So many people, when they're pursuing their immigration applications, maybe husband may make an application, wife and children may make an application, and before you know it, you've got these different applications proceeding separately, and then decisions are made. And if one person receives a notice in the family and the others don't, there's the risk of separation that family unit. And we're seeing more and more of that happening as well. So the community needs to be aware that if there's a risk of you being separated from your family because you've received a notice and others haven't, you need to outline to the Home Office that you cannot separate one person in the family, that you are a family unit. But those submissions have to be made. The Home Office, if they're not aware, unlikely, you know, it's unlikely that they will prevent such a thing from happening. But if they're aware, they cannot knowingly separate family units, especially when both parents are not documented.
What's the difference between these and somebody being given a removal notice and saying that they can only challenge it outside the country? Okay,
that's where you have a right of appeal, but you have to exercise it from outside the country.
So what's the difference between challenging and having the right of appeal?
Right. So you have, let's say, you have Michael. Michael now has been refused his asylum case. Okay? So Michael is told that he has a right of appeal, but he has to exercise it once he has left the United Kingdom. So it's not that Michael doesn't have a right of appeal. It means that he just has to exercise it once he has left the shores of the UK. If Michael feels that him leaving the UK is in itself unfair, and it is in itself wrong, Michael then has only one way of challenging that decision. First of all, even before you go running to the High Court for an injunction of any kind, you have to write a pre-action letter. And in that pre-action letter, you have to say why the decision for you to leave the UK is unlawful. And it's at that point that unless there has been an error in law, unless there's going to be some massive breach of your human rights, etc., those are the only real major grounds. But each case has to be looked at subjectively, individually, so you have full comprehensive legal advice. But in situations like that, where you're considered to be from a country that is safe to return to, you've not been in the UK for a long time, you don't have any other family members that you're separating yourself from, children, you're not caring for somebody who's seriously ill, and you're deemed able to leave the United Kingdom and exercise the right of appeal, then it's difficult to challenge. And the only way to challenge that request that you leave first is by making your pre-action letter and then challenging it by way of an application to the High Court for an injunction. The pre-action letter in itself is where you lay out the law. You say to the Home Office, look, you've made this decision, but there's an error in law. Maybe you've not looked at X, Y, and Z in my case. You've not looked at the real risk. You didn't look at this evidence when you were referring to the decision. You haven't looked at my children or my stepchildren. You haven't looked at the fact that I'm ill and dependent on these medications. It may be one of many reasons, but you have to show that error in law primarily. Because by the time the Home Office reply and says, no, we've looked at it substantively, there's nothing stopping you from leaving and exercising your right of appeal from abroad, there's nothing, then the only way is up to the High Court. And usually their response is robust, because the judge is then going to look at their response, your situation, case law if you put it in your bundle, key evidence. A judge, when they're given a bundle, is not going to start reading your immigration file from the time you made an application. They don't have the time. They're going to look at the key factors in your case, what the legal position is, where is the error in law that I'm, as a judge, am being asked to prevent, where are the human rights that are going to be breached that I'm being asked to stop. If it's not there, number one, they're going to name and shame your lawyer. Number two, they're going to order costs against you. If your lawyer hasn't got backed up costs to pay those, then again, they're going to be criticised heavily. But if the grounds are there, the judge will order an injunction to prevent you from being removed from the United Kingdom. Once you lodge the bundle at the court, you're given a Crown Office reference number, and you either lodge at the upper tribunal or in the High Court itself. And that Crown Office reference number used to, back in the day, be enough to stop the removal. But now, no, everybody wants to see the court order. Sometimes you might get taken off the flight just as a precaution, especially if it's late at night and it's unclear whether there's an order in place or not. But usually, again, as I say, 8 times out of 10, unless it's the order is there saying this person should not be put on this vessel leaving the UK, you are flying on that flight. If an errors are made, you can, if a judge disagrees, push for an oral hearing on the papers. Again, that involves more preparation, expense, because there's going to have to be the listing of a hearing, your representatives to attend that hearing, the Home Office to obviously come and defend their decision to remove you. Again, there can be a cost decision ordered as a result of this if you lose, but that shouldn't deter you if you feel you have grounds. If you believe there are grounds, there has been an explicit and very clear error in law or a mistake, you should make these applications.
Okay, Jennifer, but I thought there has been another judgment, another ruling, Supreme Court ruling, saying in-country appeal, not giving an in-country appeal is illegal and a breach of human rights.
What that order, well, what that ruling says, and that was as a result of some people that had criminal convictions that had the automatic deportation order, which meant that if you wanted to challenge it, you had to leave the UK first and appeal from outside. So it outlines that in some cases, appealing from outside the United Kingdom is unlawful. Now, as we expressed on the programme, appealing from outside the UK is one of the most challenging things anybody could ever be asked to do. You have to pay for the hearing centre, you have to get approval from the country, you cannot contact your lawyers directly, obviously. The preparation in itself remotely is almost impossible. But it's not reflective on every single type of appeal that has been asked from outside the UK. It was quite specifically narrowed down to those who have the convictions, and it outlined about 3 cases where the appellants had significant difficulty in preparing the application. In some cases it was, as I said, you had to pay for the centre you will use in the country, make sure the people that overseeing the process are again approved, making sure your government also gave permission, pay for the video link that would appear in the court in the UK. It was just arduous, and it still is in all cases, I believe, arduous. And many lawyers, and I mean the most pristine immigration lawyers and barristers, have tried to challenge this for, I would say, since 2014 very vigorously, but unfortunately we were not heard. But this ruling is a glimmer of hope. The Supreme Court have acknowledged all of these challenges, but it doesn't go far enough. There are still people who are asked to appeal from outside, which is unfortunate.
Advice: do you need professional help at a reasonable cost? At Obaseki Solicitors we have experts in property law, human rights, criminal litigation, immigration, civil litigation, family law, business law, landlord and tenant law, employment law, Sharia law. At Obaseki Solicitors, we can provide you with advice and assistance at all levels. We have over 100 years experience in serving our local communities, and we have a new maritime and international law department. We can help you. Book a free consultation today. Obaseki Solicitors, providing you with advice and assistance at all levels.
Okay, let's go to pre-removal notices. Before somebody would have got to that level, certain things have been done. Do you want to give us an idea what would have led to a pre-removal notice?
Okay. So many people get into this habit of reporting or not reporting. And you see, if you have an application pending, then you are considered to be in the UK temporarily. Okay? So by the permission of the Secretary of State, you are allowed to make your application, be waiting, but you're usually asked to comply with something. Stay at this address that you've provided. Also come and sign every week or every 2 weeks or every month, or depending on your situation. And if you have children and it's hard for you to report every week, do make representations about that. But if there's a decision, and that this is to refuse your application, or you've made a historic application and you've had a decision and you've made representations, but things have just been left. And that's commonly the situation that we see, that there's a little bit of stagnation following a refusal or representations that have not been followed up, and you're going to report. The Home Office is looking at their files vigorously now. As we've said, enforcement has been given a massive boost because they want to make sure that anybody who's here unlawfully is removed. They don't want stagnant files. They're basically combing through these files and seeing this person has no application, appeal was finished long time ago, we need to progress this towards removal. Then the next thing is maybe to serve the one-stop notice. Is there anything that you need to tell us? A statement of additional grounds why we shouldn't remove you. Or if they see that they don't want to do that, they may just issue the 48 hours if they've got the scheduled, maybe chartered flight going to the country of origin. Maybe they've got a chartered flight going to Jamaica, so they've decided that all of the Jamaicans in the UK, this week we're going to issue them with either one-stop notices or we're going to issue them with the 48-hour notice. That means that we know that within 24 hours we will have X, Y, and Z and complete numbers for that flight. So you can see that there's a bit of a pattern that's going on in order for them to have more of a hold and systematic approach to the enforcement.
Okay, fantastic. If I've got any of my viewers watching this program and they are in such a situation, are being given a removal notice by the Home Office,
what should they do?
What should they do?
First of all, don't panic. Find out what the last application or submission was that was made on your behalf to the Home Office, what it was. If it was an application and you haven't got the decision, try to find out. Go to your lawyer, find out, get a copy. Many lawyers not giving their clients copies of their application, so clients don't even know, which is very sad. If it was a submission, which is representations, a representation is not an application. You may need to quickly put in an application. If you know that where you're going to, your country of origin, you're going to suffer harm, you may need to equally put in an asylum application or apply under Article 3 or Article 2 of the Human Rights Act. Making those submissions, especially on the one-stop notice, may trigger for you to be asked to go and claim asylum or for you to be asked to put forward more information. If your circumstances have changed since your last application, for example, you have children that the Home Office don't know about, or you're in a relationship the Home Office doesn't know about, equally, it's not right for families to be separated, so you should also let them know. If you have really, you're aware that you've actually had appeals, you've got no other resource, then you might consider going voluntarily. Now, before the notice is served, it's important that people know that there is the option to go voluntarily, and families can be offered up to £2,000 per member of the family. So again, if you want to opt for voluntary return, it's something you can ask for. You can ask for that and also find out how much financial support you'll be given. And this financial support is given in cash once you've passed through the immigration barrier at the airport. It's given on a card. So it's very important people realise that that is an option. Rather than spending thousands of pounds on a judicial review application that will not work if there's no legal grounds, why not sit down and think, okay, Kukuma, let me take, there's Bisi, there's Bola, there's Jennifer, there's whoever in the family, 2468. Let me take that money, go and rent a house back home and find something small to be doing. But only you know your situation. And again, if you get a notice, please don't panic, but do take the appropriate action as we've advised.
All right, Jennifer, I've been talking with Jennifer Obaseki. Jennifer Obaseki is a senior partner at Obaseki Solicitors based here in London. Their area of specializations include immigration, family law, housing and property law, and many other legal area of specialization. If you do have concern, you can get in touch with us on the program, with Jennifer directly, or better still, you can talk to your Citizens Advice Bureau for more advice, or go and get in touch with a qualified solicitor to deal with your case. Just make sure you get professional advice regarding your matter and stay out of trouble. My name is Tunde Alabi. Until we come your way again, stay out of trouble and enjoy yourself. Bye. As part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV.